session, but that's going to vary, obviously from woman to woman. I can say I don't think I always took longer than 20 minutes when I was pumping personally, but there are women who can, get it done in like 5 minutes. So it's really, this is going to be very individual and obviously not necessarily something that you will know in advance, but it's a conversation you need to have with your employer, and what is reasonable in terms of the length of time that your pumping breaks will take is again going to depend on sort of how, the individual needs of your employer and how your job is structured. Other things, in terms of the time, they do have to include, and you should talk about this with your employer, that even if you're pumping for 15 to 20 minutes, the break time is going to also need to include setting up, breaking down, cleaning your equipment. If the place where they have you pumping is not, where you're sitting right at your desk or right next to your work area, it's going to take you time to get to and from the work area. If you're far from a sink or running water, then you're also going to have to then go to that spot to clean out your pump parts. And then if they have you storing your milk in a third location, you're going to also need time to get there. So all of those things are going to need to be part of your conversation when you're thinking about how long are these breaks reasonably going to take. In terms of, paid versus unpaid breaks, the law really only requires generally your employer to give you unpaid breaks, but the law does also say that if your employer is already giving employees paid breaks, then you can use your paid break time to pump. They can't deny you compensation for those breaks just because you happen to be using them to pump. And also, again, under the Illinois law, the idea is that your employer needs to treat you the same way that they treat other employees. So if your employer has a practice of giving additional break time or flexible schedules to employees who need it for like temporary illness, like if they have a sick child and the employer allows them, flexible schedule, things like that, then that suggests that there's no undue hardship, that the employer could make those same breaks or flexible schedules available to you. So it's really important to know sort of what it is that your employer does generally, and what it is that they consider to be kind of an undue hardship. In figuring out break time, you can also talk to your coworkers and find out what they've done in situations like this. Also, if you have coworkers who are willing to cover for you on breaks, that may be something that you want to find out in advance if you think your employer is going to have objections. Just to kind of talk about some other options, if your employer is really expressing concerns, is really pushing back on, I don't think we can find a space, I don't know how we're going to schedule breaks. Again, in this conversation that you're entitled to have under the law, you can suggest possible options. You can come to your employer with, different suggestions. Your employer has to give you a timely response, has to consider those things in good faith, and your employer can suggest alternatives too. And there are resources out there, including the womenshealth.gov website that Katrina pointed to earlier, that give a lot of suggestions if you have an employer that is really having trouble finding ways to accommodate you. That doesn't mean that these are necessarily the gold standard for accommodating somebody who pumps, but particularly if you're working in sort of a challenging industry, things like thinking if you're in retail, maybe there's a dressing room that they could convert, or really any kind of small, clean area. It only has to be, 4 feet by 5 feet, that they could put up like a temporary partition or a curtain. Again, that's not really the gold standard, but if you have an employer that is facing some serious hardship in trying to accommodate you, there are lots of suggestions out there and creative ways to accommodate it. Again, with breaks, kind of the obvious standard solution is, regular breaks and meal times, or, coming in early and staying late to kind of accommodate for, whatever that extra 15, 20 minutes are. If you're working a restaurant or somewhere that has sort of obvious busy periods and downtimes, working a split shift or having breaks during the downtime, or again, talking to coworkers or somebody else to figure out if there's ways that they may be able to cover you during breaks. On this sort of topic of talking to an employer that is resistant or that is really expressing some significant concerns about whether or not they can reasonably accommodate you. You may want to look into these resources about the ways in which it benefits your employer to support parents and to accommodate employees who choose to breastfeed. This is sort of part of the idea that employers who create family-friendly workplace policies, those employees that work at those workplaces are likely to stay longer. They're less likely to quit. They have higher morale and job satisfaction, even among, in some cases, male employees, because they feel supported as parents. Studies have found that they have higher productivity and that there's less absenteeism. That doesn't mean that your employer needs to then go overboard and punish employees who have children and don't breastfeed them. But these are sort of pieces of research that you can bring in if you're working with a supervisor or an employer who kind of says, well, why should I do this? Why is this? Why isn't this just a huge burden on everybody? So we've kind of talked about how to apply at least the Illinois law to your situation, and how to think about that when you're having this conversation with your employer. And I'm getting to some slides that have a lot of detail that I am really going to just kind of skim over. And again, these slides are going to be available as a handout, as an email attachment later. And the point that I want to make is that the Illinois Human Rights Act, which we've talked about, has the broadest protections and applies to the most employees in terms of, again, requiring that your employer make reasonable accommodations for you in expressing breast milk and not retaliate against you or discriminate against you because you're breastfeeding or you've asked for accommodations. There are other laws that also specifically require accommodations for pumping at work. In Illinois, there is the Nursing Mothers in the Workplace Act, which applies to most employees, and again is going to require reasonable unpaid break time generally, and again reasonable efforts to offer a private non-bathroom space near your work area. And there's also at the federal level, there's the Fair Labor Standards Act, which applies to a lot of employers applies to some employees. The federal law is limited to the child's first year. The Illinois laws do not say how long you can pump for. The Fair Labor Standards Act may not cover white-collar type positions where you don't get overtime pay. And again, it is really supposed to require that you have reasonable break time whenever you need to pump, and again that you have this private non-bathroom space to pump in. The laws have different enforcement mechanisms, which I'm going to get into a little bit more. And then I also just want to point out that there are several laws that also say that you cannot discriminate, as an employer, discriminate against an employee because she's breastfeeding or lactating or because she's asked for accommodations to pump. Again, the Illinois Human Rights Act requires that. Also at the federal level, Title VII or the Pregnancy Discrimination Act applies to many employers, and again says that you cannot discriminate generally because an employee is lactating, that is discrimination because of pregnancy or because of sex. And then in Illinois, there's also the Right to Breastfeed Act, which is not so much about employment, but basically says that all mothers have a right to breastfeed their baby in any public or private location where they're otherwise authorized to be. And again, I don't want to get into too much detail with these laws, and they're really going to be more useful if you're at the point of working with an employer that seems to really think that there are no laws that require this. The point is that there are several laws that have these requirements, and that if you need to really cite as many laws as possible, there are 5 different laws that may apply to your situation. And the other point that I want to make is that these laws have different enforcement mechanisms. The Illinois Human Rights Act that we've talked about mostly, it is enforced through the Illinois Department of Human Rights, and the federal employment laws are enforced through the EEOC, the Equal Employment Opportunity Commission, and those agencies cross-file with each other, so you would only need to go to one or the other. And the biggest thing to keep in mind is that these laws do have time limits. Generally, you're going to need to file a charge within 6 months of whatever the negative employment action was that occurred. So if you were fired, if you were disciplined, if your employer denied you accommodations to breastfeed, and you decide that you want to sue, you are limited in terms of you need to get that charge filed usually within 6 months. And these other laws that I've talked about have different enforcement mechanisms. The Federal Fair Labor Standards Act is handled through the U.S. Department of Labor, or you may be able to file directly in court if you've actually lost wages or overtime pay as a result of your employer denying you, for example, paid break time. And then these other laws, the Illinois Right to Breastfeed Act, you can go to court to stop denials of the right to breastfeed, and the Illinois Nursing Mothers in the Workplace Act, even though that's an important act that really that a lot of employers know, and that puts some specific requirements on employers, it's not really clear how that is enforced, but it could be evidence of a violation of the Illinois Human Rights Act. So again, you would go to the Department of Human Rights. And if you're really at the point of thinking that you want to take legal action against your employer, I would suggest contacting a lawyer or contacting agencies directly to get a better understanding of what these requirements are, because this is sort of a very quick and dirty overview. So in terms of resources, these are the citations for the laws. Again, we'll send this out so that you can look at this at your leisure. This is the sort of how to contact those agencies that I just talked about in the previous slide. And we've also got a link to the womenshealth.gov website. The CDC website offers some resources. We've got a link to Breastfeed Chicago and the ACLU of Illinois, our website, and some of our fact sheets and blog entries. And so just to wrap up, the big things that we want you to remember out of this sort of wealth of detail about the law and how to think about this conversation, know your rights under Illinois and federal law. Know that your employer must make reasonable accommodations. This should include breaks. This should include a private non-bathroom space. And you're entitled to this conversation with your employer where you both really work together to try and find these accommodations, and that they can't discriminate against you or retaliate against you because you're breastfeeding or you've asked for these accommodations. And you really want to prepare for your conversation with your employer. You want to think about what are the topics you're going to discuss. You want to make sure you understand what your employer's policies are in advance and follow any of those policies if there are requirements there. And think about when you want to have this conversation, and think in advance, and also even if you're having kind of this back and forth with your employer, there are lots of resources out there and ways to think about kind of creative, reasonable accommodations. And you can look to what does the employer do when somebody's ill or injured or has other needs for accommodation, and you can suggest those options to them. And I think that's